Question number 9, the Honourable David Parker.
Thank you, Mr Speaker. My question is to the Attorney-General. Is he aware of the widespread criticism of the Marine and Coastal Areas Takutai Moana bill from both Māori and non-Māori submitters, and does he have confidence that the bill will provide a durable framework for consideration of foreshore and seabed claims?
The Honourable Chris Finlayson.
Yes and yes.
The Honourable David Parker.
Does the Minister intend to seek any assurance from the Māori Party that they accept the government's new foreshore and seabed bill will, if passed, fully and finally settle the legal framework for consideration of foreshore and seabed claims? And if no such assurance is forthcoming, will he be willing to consider adopting the solution favoured by Labour, the Greens and the ACT Party, and many submitters, Māori and non-Māori, who say the issue of the threshold test, as well as the unextinguished rights, ought to be referred back to the courts, with statutory protection for access and non-alienation?
The Honourable Chris Finlayson.
Well, I'm not really quite certain where the Labour Party stands on this issue, because that may be the latest permutation, but the submission by Dr Cullen, a very good submission to the Ministerial Review Panel, emphasised the need for codification of the tests and said, and I quote, "To wait upon protracted legal arguments developing in New Zealand jurisprudence in this respect would defeat the purpose of what many are seeking, both certainty and equity." And so in response to the second part of the member's question, I'd say certainly not. The suggestion's ridiculous.
The Honourable David. I beg your pardon, the Honourable Tauhanarei.
Thank you, Mr Speaker. What does he think these criticisms mean in terms of finding a durable framework for consideration of foreshore and seabed claims?
The Honourable Chris Finlayson.
Well, as I said in answer to the member's supplementary question, Mr Goff seems to criticise the inclusion of tests to determine customary title, but as I said, that contrasts with what the ministerial panel submission by the Labour Party said. That said that the test should be retained. Mr Goff also seems to think that we should just leave everything to the courts to decide, and again that contrasts with section 96 of the Foreshore and Seabed Act and Labour's 2008 agreement with Ngāti Porou. So it's very hard to find out where the Labour Party stands on all this sort of thing. They're about as consistent as vomit.
Order. I think the last part of that answer went over the top. The Honourable David Parker.
Supplementary.
Order. I've called the Honourable David Parker.
Will the Minister agree to amend the government's bill so as to require that any proposed agreement between ministers and claimants to confer customary title under that bill would be referred to the courts for ratification, as is currently required under the Foreshore and Seabed Act for negotiated agreements under that Act?
The Honourable Chris
Well,
Finlayson.
the negotiated agreements deal with foreshore and seabed reserves. What I've said all along is that when the submissions have been concluded, I'll have a good look at them, and if there are issues that need to be addressed, they will be addressed. That's the sensible thing to do when one is dealing with submissions which are still being heard by the Select Committee. I know, for example, Waikato, Tainui and Ngāti Porou are yet to make their submissions to the Select Committee.
John Biscowen.
Thank you, Mr Speaker. A supplementary to the Attorney-General. What does he make of Mr Quinton Hayes' submission on the bill, or has he not bothered to read it?
The Honourable Chris Finlayson.
I think the member probably means Mr Quentin Hay, who's a former partner of mine in Belgully. If that's the person, I haven't read it, but I certainly will, and then I'll give him my considered view.
John Biscowen.
Thank you, Mr Speaker. Was Mr Quentin Hay correct in his submission when he said the Attorney-General must have been misreported in the comment?
Order. The Minister has no responsibility whatsoever for answering whether someone was correct or not. No responsibility. The member can ask him his opinion on certain things, but he can't ask him to accept responsibility as to whether or not someone's correct when the Minister has no responsibility for that person whatsoever. Point of order, the Honourable Trevor Mallard.
Speaker, I think the second clause of the of the member's question actually brought it in, and because it went to whether or not the minister had been misreported or not.
I was about to let the member rephrase his question. I asked John Biscown to rephrase his question to bring it within standing orders.
Does the Attorney-General agree with Mr Quentin Hay when he says the Attorney-General must have been misreported in the comment that ministerial deals provided for in Clause 93 are akin to the settlement of a private dispute because the Attorney-General's argument is, quote, fallacious?
The Honourable Chris Finlayson.
Yeah, that sounds like Mr Hay. No, as I've said, I haven't read the submission. I'm always very wary, with the greatest of respect to Mr Boscawen, to listening to selective quotation. I will read the submission and then I'll give him my considered view.
Question number 10, Katrina Shanks.
Thank you.